time, I call the honourable member for Denison.
Thank you and good morning, Deputy Speaker.
Good morning to you.
Deputy Speaker, I am very concerned with the Migration Amendment regaining control over Australia's protection obligations bill, and in particular I am very concerned with the way it would alter the process for complementary protection and the way it would be given. I'll start again. The way that complementary protection will be decided, in that it fundamentally alters the process that occurs before someone might be granted complementary protection. Deputy Speaker, this is all about abolishing proper process, and that is something we should be all very, very concerned about in this place. Currently, of course, there are some people who make application to come to Australia or who come to Australia, and they don't fit neatly within the provisions of the Refugee Convention for any number of reasons and no fault of their own. And often these cases are very, very tragic, and there is a self-evident and pressing need to give those people protection. Up until now, there has been a proper process and a good process. People who might fit within the category of this complementary protection, they could make their case to the Refugee Review Tribunal, and if there is an unsatisfactory outcome at the tribunal, they might try and progress their matter through the federal or even the High Court. Now, that would seem to be an eminently sensible, appropriate, reasonable way to respond to those people, particularly for a civilised, wealthy, lucky country like our own. They have the opportunity for their circumstances to be reviewed, the opportunity to appeal if there's an unsatisfactory outcome. It delivers them natural justice and procedural fairness, just the sort of thing that a country like Australia should have in place and should be proud of and should work hard to defend. But this government would do away with that. In fact, basically abolishing the whole process and saying it's up to the minister for him or her to make a case on a case-by-case basis. Now, that may well work when you've got a very, very fine minister, and I'm not making any criticism of our current minister or previous ministers, but what happens in the future if you were to have a ruthless minister, someone lacking compassion, someone wanting to, for their political benefit, to clamp down to even do away with entirely people getting complementary protection? He or her would have that power. Now, we shouldn't have laws of the land that rely upon good people being in these positions at all times. Our regulatory framework must provide protections against a bad minister or someone making bad decisions. So this abolition of the process is a fundamentally bad thing. Now, let's put a human face to this. Between March 2012 and November 2013, I'm advised that only about 55 protection visas were granted on the complementary protection grounds. So we're not talking a lot of people. So why on earth would the new government want to so brutally attack proper process, so brutally put at risk the welfare of people genuinely in need for the sake of so many people coming to this country and getting protection? People like, and if I can give a few examples, because I think we need to personalise this. Far too often, the debate in this country about asylum seekers and irregular immigration, it's about grand policy, grand announcements, and we sometimes lose sight of the fact we're talking about human beings, men, women, girls, boys, babies. Every one of them a precious human being with their own story to tell. If they were members of our extended family, I'm sure some people in this place would take quite a different approach to them. One story comes straight to mind, a story I've been involved with quite recently. Living just outside of Hobart is an Iranian, and I'm sure he won't mind me mentioning his name. He's known as Afi. Now, Afi is a young man. He came to Australia from Iran. He's gay, and it is a particularly tragic story. Afi was reported to the authorities by his father for being gay. Afi was arrested, taken into custody in Iran and was brutally beaten, and he still carries on him to this day the scars from that episode. He fled to Australia with his partner. He eventually made it to Australia, but the previous Australian government, the current Australian government, do not see fit to quickly give him protection. He may not actually fit neatly in the criteria of the Refugee Convention, but he certainly would fit neatly within the provisions of complementary protection. But regrettably, he's on a bridging visa, last I'd heard. Now, Afi, if returned to Iran, will genuinely go back in fear of his life. It is a serious crime to be gay in Iran. People are put to death for being gay in Iran. Why on earth would this government or any government want to deny Afi, for a start, protection immediately and give him certainty that he can stay in Australia? And why on earth would any government, Deputy Speaker, want to do away with an effective and proper process that hears the claims from people like Afi and gives people like him protection when those claims are found to be warranted? That's what a civilised country does, a rich country, a lucky country. But instead, this government, Deputy Speaker, wants to do away with the sort of process that would effectively hear Afi's claims and give Afi rights of appeal to the federal and high courts if his claims are not handled in a way that gives a satisfactory outcome. Some other examples. Now I know Afi personally. I mean, and I can say he would make a very, very fine Australian. He desperately wants to be an Australian and to contribute to this country, and he would be a real asset to this country. He would bring skills and a little bit of a very rich Persian culture, which would make this country all the richer and better if only we were to let him stay permanently. But there's some other examples I read about, people who have in fact been given complementary protection in recent times. For example, and I won't mention names, Deputy Speaker, in these cases, but one person, a native of Ghana, he developed a mental illness after the death of his parents and fled to Australia. Now, if this person was not to have been given complementary protection and was forcibly returned to Ghana, there would be a very real risk that this person would be placed in an institution in that country, which are awful places, a country where people with mental illness are treated, well, they're often not treated at all, but to the degree that they are handled by the authorities, it is in a terrible, terrible way. Now, this person, he made it to Australia. He went through the existing arrangements for complementary protection, went through proper process. He's been given complementary protection. That's a good thing. Another example, a native of Nepal who gave information to the police in Nepal. Now again, and fled to Australia. Again, someone who wouldn't fit neatly within the Refugee Convention, but someone who is well suited to the provisions of complementary protection. He can't be sent back. He has given information to the police and is at risk from a very broad network of criminals in that country. Again, just the sort of person doesn't fit neatly within the provisions of the Refugee Convention, but someone that really does deserve to have his case heard properly through proper process, resort to appeal through the federal and high court, and so on. Another example, someone from Syria. He was persecuted for his Christian background and practices, made it to Australia. There wasn't actually enough evidence in this case for him to be granted protection under the Refugee Convention. Again, he was granted protection under the complementary protection provisions. An interesting thing about this case, he has low advocacy skills, couldn't make the case very effectively, but yet it was self-evident to those people who were dealing with him that this is someone that was being persecuted and genuinely warranted protection in this country. But he couldn't quite get over the line with the Refugee Convention and its requirements. Again, just the sort of person that needs to have that certainty that he or she can go through proper process in Australia, can make an appeal to other courts if his claim is not handled satisfactorily in the first instance. Just the sort of person that, if it was left to the minister, Deputy Speaker, depending on the whim of the minister at the time, might just say, oh, yes, mate, oh, yes, or oh, no, I've had a bad day this morning, or our numbers are up, I'll say no to this character. Another example. This is 3 people who came from India, a daughter and her parents. Had entered into a marriage which was violent and cruel, so she wanted to leave. But her husband threatened to bring a false dowry claim and have her daughter abducted and raped to force her compliance. Now, again, doesn't fit neatly within the Refugee Convention, but does meet the criteria for complementary protection. Just the sort of person, again, that needs to have the certainty of being able to front up to the Refugee Review Tribunal, have her case heard. If it's an unsatisfactory outcome, know that she's accorded natural justice and procedural fairness, can make appeal to the Federal Court or the High Court and get a satisfactory outcome, hopefully at the end of the day. Again, we don't want someone like that at the whim of the minister of the day. Maybe we'll have a good minister who'll say, yep, no problems there, that person can have protection. But what if it's a ruthless minister or a politically motivated minister or someone who just wants to put a cap on the numbers one year and that person misses out? Not the sort of behaviour that a rich and civilised country like Australia should be affording anyone. Deputy Speaker, this is all about minimising the number of people coming to this country and having in place a ruthless regime of deterrence. That's what this is about. This is another theatrical episode by the new government to appear tough on those people that don't look like us that want to come to our country. Another example of a cruel and ruthless policy by this government, which I would add is not much better, or sorry, not much worse, but a bit worse than the regime by the previous government. We've had a succession of bad policies by bad governments, in my opinion, when it comes to irregular immigration. But I tell you what, just when you thought the previous government couldn't make things any worse, the new government is. Again, committed to offshore processing, a cruel arrangement, committed to mandatory detention, committed to temporary protection visas. These aren't in accordance with the spirit or the word of the Refugee Convention. It's about time Australia started to act like the civilised and rich country that we are, and we started to honour both the wording and the spirit, Deputy Speaker, of the Refugee Convention. And until this country adopts a more humane and legal response to irregular immigrants, we're going to be seen very, very badly in the international community, as we should. This shouldn't be about putting in place a brutal deterrence regime. This should be about Australia acting like the civilised and wealthy and lucky country that we are. And what we should be doing, Deputy Speaker, is when someone comes to our shores or from offshore makes application, particularly when they come to our shores, we should give them protection. We should hear their claim, and we should give them permanent refuge if those claims are found to be true and honest. That's what we should be doing. As a signatory to the Refugee Convention, that's what we should be doing. And when there are people who come to Australia who don't fit neatly within the Refugee Convention, but it is self-evident that they're in strife and that we should do the right thing by them and we should give them protection, we should make sure we have in place the very best process for the granting of complementary protection. We should have a proper and full process, one that accords people natural justice and procedural fairness. So we should hang on to the Refugee Review Tribunal. We should still allow it make the decisions about complementary protection. We should allow people to continue to make appeal to the Federal and High Court if the outcome has been unsatisfactory at that early stage. That's what we should be doing. That's what a civilised and rich country should be doing. So I will not be supporting the migration amendment regaining control over Australia's protection obligations bill. I suspect I'll be one of very, very few people. Prove me wrong, Labor. Hopefully Labor will oppose this as well. I pray they will. But it's about time Australia started acting like the sort of civilised and lucky country that we are. Thank you, Deputy Speaker.
Thank the member for his contribution.